Your Honours, in their final trial brief and closing arguments, the prosecution tried to represent Stojan Župljanin as a person who was crucial and played a key role in the persecutions and murders. It is our position, Your Honours, that there is considerable, overwhelming evidence that refutes these positions advanced by the prosecution, and I'm referring primarily to some of the key documents that my colleague Aleksić mentioned, including P2065, P355, P160, the last one being very important because it is the 11th of July speech by Mr. Župljanin, where he pinpointed some of the key problems in the workings of the MUP. Among other things, for the first time, a senior high-ranking officer pointed to the existence of camps, the prevailing poor conditions in them, long before this became public knowledge. He indicated the problems that we addressed during this trial, the problems with the army, resubordination, the operation of the communication system, the fact that the judiciary was not working, and many other things. If Mr. Župljanin voluntarily, as the prosecution put it, participated in the development of a joint criminal plan, why did he address these issues on the 11th of July? Why did he advocate that better conditions be put in place? Why did he intercede and advocate that they be released? The crucial document that their honours should bear in mind when deciding about the character of Mr. Župljanin and his sentence is 2D25. Look at the start, look at the beginning of the document, Your Honours, and find there how it is that Mr. Župljanin described the situation in the area of responsibility of the Security Services Centre. He speaks about armed rebellion, acts of violence, crime, looting, flouting the law, civilian or civil disobedience, and all the other occurrences that characterized the situation in Krajina at the time. What you will not find in any other document is to be found at page 2 of this document, where he says that the situation such as this one creates fear among other ethnic groups and unavoidably causes ethnic division and a lack of confidence in the institutions of the system. Would this be the way that these matters would be addressed by a person who was an important member of a criminal enterprise? He does not hesitate to say at the bottom of the second page and at the top of the third page of this document, and to criticize and draw the attention of the police in public security stations to all these various facts. And at the end, Your Honours, you will see that there are 11 items containing 11 orders that he issued in the document, namely that the failure to obey any orders, including the army and the main staff, would be contrary to the law, that no tasks should be taken on, such as to guard prisoners who have been unlawfully detained, taking essential, resolute and uncompromising actions to shed light on or detect any crime present in stations, filing criminal reports to prosecutors, and where there is no prosecutor's office active in one's area, reports should be filed to the second prosecutor closest to the area. A detailed analysis of this document will undoubtedly show that this is not the sort of situation to which an old saying would apply, that the only necessary thing to fight evil would be for a good man not to do anything. Your Honours, in assessing the evidence, look at P601 and P595, P621 and P624. From these documents, it will become clear to you that Mr. Župljanin was committed to the maintenance of law and order for all individuals, regardless of their religion or ethnicity, that he was not afraid to point to the unlawful activities on the part of his subordinates, or those who were supposed to be his subordinates, and that he did everything in his power to prevent such activities. Finally, I'd like to remind their honours of two events that shed light on the personality of Mr. Župljanin, namely the events in Stanišić, where Mr. Župljanin secured the release from detention of several hundred Muslims and Croats in the course of the Mićo action, and the incident along the Stanišić road, where Mr. Župljanin prevented the killing of 600 non-Serbs. The appropriate references are at pages of the transcript. Can Mr. Krgović please repeat the reference slowly? 2598 to 2599.
I strana transkripta.
Transcript pages 11020 and 11021. Your Honours, my brief presentation so far and the documents and exhibits I referred to did not reflect anything of the kind in this case or in the cases that are before the BH state courts, Župljanin's words and Župljanin's actions. That's what I meant. Your Honours, I have concluded my presentation. I will now give the floor to Ms. Butler, who will be speaking about sentencing and some other legal issues.
Good morning, Your Honours. I will now make some short submissions on matters of law and then sentencing, and that will conclude the presentation for the Župljanin defence team. In a criminal trial, Your Honours, there are many cumulative elements that must be proved beyond reasonable doubt. Each and every one has to be proved, and if one fails, the whole case fails. We say that the prosecution has not proved every single element of any of the modes of liability that they put in their indictment. Unfortunately, I don't have the luxury of time to go through the complex web of liability that's alleged against my client, but I will make some brief and I hope illustrative comments to demonstrate my point in relation to joint criminal enterprise, in relation to command responsibility, and aiding and abetting. For the sake of clarity, the defence also maintain that the prosecution is a long way off proving the other modes of liability charged in the indictment. That is, planning, instigating, and ordering. The prosecution themselves may also recognise this, as despite the more than 1,000 paragraphs in their beautifully put final brief, and despite having a number of specific sections dealing with modes of liability, there is no discussion of Mr. Župljanin's apparent liability pursuant to the doctrines of planning, instigating, or ordering. It is the defence submission that this omission speaks volumes about the strength of the prosecution's evidence on these modes. I will turn first to joint criminal enterprise, or JCE. For better or for worse, this doctrine is now part of the landscape of this tribunal. However, as the appeals chamber has taken care to emphasise in the Župljanin case, the doctrine may not be applied so as to give rise to guilt by mere association. That is not enough. As the appeals chamber was keen to highlight in that case, all of the elements of the offence must be proved by the prosecution beyond reasonable doubt. In her submissions, my learned friend Ms. Corner acknowledged that there is no direct evidence of Župljanin's alleged discriminatory attitude towards non-Serbs. As she put it, at transcript T27365, Župljanin was not a Župljanin. He wasn't a Vukic. He wasn't a Kalinic. I can see my learned friend shaking her head, and I will correct that. She did go on to assert that if you look at his actions, they have no other explanation but of his wholehearted endorsement of and involvement in a Bosnian Serb criminal plan. Now, Your Honours will be well aware of the test for conviction for a JCE where it relies upon circumstantial evidence. We say, and this has been affirmed recently by the Haradinaj trial judgment, that participation in a JCE, when relied upon by circumstantial evidence, must be the only reasonable conclusion on the evidence. Your Honours, in our respectful submission, the prosecution have not proved to the requisite standard that there is no other theory that could explain Mr. Župljanin's conduct, except for his participation in a JCE. Despite all their hard work, despite all their diligence, the prosecution evidence just does not withstand scrutiny on this issue. This is because the defence suggests that Mr. Župljanin's good character is such that it tends to negate the suggestion that he willingly participated in a JCE. Now, we accept wholeheartedly Mr. Hannes's observation yesterday that good character is not a defence to the charges. That's not what we're saying. What we are saying is that if a person is of good character, and specifically with respect to Mr. Župljanin, is known to be non-discriminatory, that is both relevant and probative for the purposes of determining his proclivity to participate in a common criminal plan. Your Honours will undoubtedly recall the host of evidence highlighted in paragraphs 56 to 75 of our final brief, which originates from both prosecution and defence witnesses, and which illustrates what we say is the true and non-discriminatory character of my client. We say that this is significant evidence, and it cannot be readily dismissed. When Your Honours deliberate on the evidence in this case, we would ask you to ask yourself, is Stojan Župljanin the kind of man with a burning hatred of non-Serbs? Is he the kind of man who would willingly commit the kinds of heinous acts that are alleged by the prosecution to be part of this JCE? Is it really possible to reconcile the police officer described by many as a person of the utmost integrity, who went out of his way to treat all religions and ethnicities equally, and who took care during the war to ensure that the businesses of local Muslims thrived? Is it really possible to reconcile that officer of the law with the lackadaisical, uncaring, and highly prejudiced individual described by the prosecution. Your Honours, a JCE theory, however much work has done upon it, however much analysis, however many hours are spent on it, should not be accepted by strength of repetition. In our respectful submission, the evidence in this case does not show that there is no other explanation for Mr. Župljanin's conduct but for his participation in a JCE. I will deal next with the issue of command responsibility. Your Honours will be well aware that the concept did not evolve as a matter of strict liability, whereby a commander is responsible for every single act by every single person, whether the commander knows about that act or not. The Celebici trial chamber said on this subject, at paragraph 77 of its judgment, great care must be taken lest an injustice be committed in holding individuals responsible for the acts of others in situations where the link of control is absent or too remote. To determine whether Mr. Župljanin was able to exercise effective control in the chaotic situation that existed in the Krajina in 1992, the trial chamber should not rely solely on his legal authority, but must instead study the evidence as to what practical control he had over his purported subordinates. We note that the prosecution themselves accept at transcript page 27330 that the course of the relationships between the political, the army, and the police did not always run smoothly. It is our case that in actual fact, the relationship between these three bodies was so fractured and disproportionate in terms of the real power that the crisis staffs and the army had, that it completely subjugated Mr. Župljanin's authority over local police, who by law were meant to be his subordinates. We say that the practice of resubordination of police officers to the army to engage in combat tasks is problematic for the prosecution's case on command responsibility. This is because any confusion as to the chain of command has the effect of negating the existence of effective control. We say that this raises a reasonable doubt as to whether Mr. Župljanin had effective control over the perpetrators of the crimes. I will deal now with some matters raised on Wednesday in the course of Mr. Olmsted's well-put submissions. The particular references are at transcript page 27441 to 27443. In his submissions, Mr. Olmsted referred to what he regarded as persuasive authority from the Popović trial judgment. In that authority, Mr. Borovčinin was found to have retained effective control over RSMUP police special units even when they were resubordinated and were committing crimes in Potocari. In the interest of time, I won't read out the full extracts from that judgment, but I would certainly invite your honours to have a look at that in due course. When one does, one can see that Mr. Olmsted is quite correct to note that the trial chamber, and paragraph 1568 of that case, did recall the principle of unity of command under which MUP forces resubordinated to the VRS retained the internal chain of command. They did find that. However, that case can be readily distinguished on the facts from that of Mr. Župljanin. Quite apart from the evidence about Mr. Borovčinin's receipt of a contemporaneous report from the units in question, and putting to one side his presence in Potocari at the relevant times, paragraphs 1567 and 1568 of the Borovčanin judgment indicate that Mr. Borovčanin gave an interview to the prosecutor in which he did not contest that the troops in question were under his command and control. Likewise, the evidence cited in those paragraphs indicates that Mr. Borovčanin's orders were in fact followed by those subordinate units. We suggest that these facts are very different to those in the present case, where we say that first, Mr. Župljanin's command and control of his alleged subordinates is contested, and second, in practice, Mr. Župljanin's orders were not actually followed by those subordinates. The next issue addressed by Mr. Olmsted was in relation to Your Honour Judge Hall's question about the Tribunal's case law supporting the proposition that a subordinate can be under the command of more than one superior, and that each said superior can be held responsible for the subordinate's crimes. Now, in answer to that question, Mr. Olmsted cited the case of Strugar for this proposition at paragraph 367. Now, it may be an error on the transcript, but from my study of the judgment, I think he must have been referring to paragraph 365, because in that paragraph, the trial chamber recalled that the test of effective control implies that more than one person can be held responsible for the same crime committed by a subordinate. But if one has a look at the context to that quote, so specifically if you read paragraphs 361 to 366 of that judgment with care, it's plain that the Strugar judgment, Strugar trial chamber, in fact, as it says in terms in paragraph 361, was concerned with the issue of whether a commander may be found responsible for the crimes committed by a subordinate 2 levels down in the chain of command. So they were talking about a vertical chain of command. It was specifically not concerned with the proposition which Mr. Olmsted seeks to establish, namely that parallel chains of command are recognised in the case law of this tribunal. Turning back to command responsibility more generally, in conclusion, quite apart from the issue of effective control, given the insufficient evidence to prove beyond reasonable doubt Mr. Župljanin's knowledge of crimes and his failure to take measures to prevent and punish those crimes, we say that he cannot, therefore, be found liable pursuant to this mode of liability. I will deal now with aiding and abetting. The prosecution maintain that Mr. Župljanin is also liable for aiding and abetting the crimes charged in the indictment by way of both his actions and his omissions. I will deal with both allegations relatively shortly. First, in relation to his actions, it is plain that the elements for this mode of liability cannot be made out on the evidence. There is no evidence proving beyond a reasonable doubt that Mr. Župljanin's acts had a substantial effect on the commission of the crimes. It is also not proved that Mr. Župljanin took a decision to act in the way he did in 1992, in the knowledge that he would be supporting the individuals committing indictment offences. Indeed, the evidence, as was outlined in our final brief, as well as during these closing submissions, shows the very opposite. Mr. Župljanin was horrified by any crimes he heard about. He took steps to try and prevent these occurrences and to try and punish the perpetrators. Second, in relation to aiding and abetting by omission, the trial chamber will be very well aware of the limited jurisprudence to date on this mode of liability. It is the defence submission that if one scrutinises the Borovčanin trial judgment, which is the leading judgment on this area, particularly at paragraphs 1543 to 1563, that it's immediately obvious that the alleged omissions of Mr. Župljanin in this case are of a wholly different scale to the alleged omissions, of Mr. Borovčinin in relation to the massacre at the Krivica warehouse. For these reasons, we say that the elements of aiding and abetting, either by action or omission, are not made out. My final submissions relate to the issue of sentence. For the sake of clarity, it remains the position of the defence for Stojan Župljanin that our client is not guilty, and that the only proper verdict that you may return in relation to the charges is that of an acquittal. Although we still proclaim the innocence of our client due to the tribunal's settled, yet still very unfortunate practice of conflating submissions as to conviction and sentence, we will take this opportunity now to make some brief remarks. We note in the prosecution's final brief at paragraph 999 that it says both men, presumably meaning Stanišić and Župljanin, are responsible for crimes committed in a series of at least 52 detention facilities. The prosecution make no attempt to distinguish between the crimes for which Mr. Župljanin is charged, which relate to 22 detention facilities, and the other crimes mentioned in the indictment, for which he is not alleged to have been involved in any way, shape or form. This tarring of Mr. Župljanin with crimes for which he's not charged must be a mistake. It is certainly a regrettable one. It's trite law to state, of course, that the trial chamber must consider the exact role of each individual accused before determining an appropriate sentence. The trial chamber must carefully take into account both their intention as well as their acts and omissions. Bearing this in mind, even taking the prosecution case at its highest, for the prosecution to suggest that Stojan Župljanin should receive a sentence of life imprisonment, we say is nothing short of absurd. Not one of the more than a dozen individuals convicted at this tribunal for crimes taking place in the Krajina have had a life sentence upheld on appeal. Not one. This kind of blanket submission as to the maximum available penalty, without any form of tailoring to the crimes charged, without any guidance by reference to comparative sentences handed out at the tribunal for similar crimes, is of no help whatsoever to a trial chamber trying to come to a fair and just outcome. Sentences thus far handed out to individuals for crimes committed in the Krajina region following a contested trial range from 40 years at the highest end. That was for Stanišić, who was found to have orchestrated and actively participated in the tragic events taking place at Prijedor. And at the low end, they go right down to 5 years. And that's for Prakač, a retired police officer working at Omarska, whose silence in the face of crimes committed there was found to have given tacit support to the perpetrators. Your Honours, we say that even if, contrary to all our submissions, you find that Stojan Župljanin has played a part in the allegations made against him, then in light of the lack of direct evidence as to his direct involvement in those crimes, in the light of his efforts to prevent and punish those crimes, and in light of his good character and his lack of discrimination against non-Serbs, we would say that a punishment at the very lowest end of that spectrum is the right disposition of this case. Thank you, Your Honours.
Thank you, Ms. Butler. I take it, Mr. Krgovic, that that was the final word from the defence of Župljanin.
Sude, ovim smo mi za...
Your Honours, this concludes our closing arguments. I would like to inform the trial chamber that my client, Stojan Župljanin, would like to address their Honours to make a few points, with your leave.
Yes, thank you. We've been alerted to that. Yes, thank you. Before we inquire of counsel with the prosecution as to whether they have any submissions to make by way of rebuttal in accordance with Rule 86A, the Chamber, in the person of Judge Harhoff, has one matter on which he would seek counsel for the prosecution to explicate.
Thank you. The Chamber has listened with great care to what both parties have said, and there was one little issue that was raised, I think, by Mr. Olmsted, but I am not sure, that we would wish to have just some clarification, if possible. And that is the issue of whether within the context of a JCE 3 crime, that is to say a crime that was committed not as part of the common plan, but nevertheless was a foreseeable crime, whether the prosecution is of the view that such a foreseeable crime could also be a crime that carries dolus specialis, a special intent. There is a discussion about this in several instances, and we would just wish to know what the prosecution's position is on this matter, if possible. Thanks.
We're slightly taken by surprise by that. If you will just give us a moment also to discuss that.
Should we rise?
Yes. I mean, at the moment, when you say, could we perhaps ask for a little clarification, because Mr. Olmsted has in fact is going to deal with the matters that were the cause of some discussion yesterday in relation to the resubordination and the dual control. We hadn't anticipated this question. Could we inquire which particular crimes Your Honour had in mind as requiring dolus specialis?
Persecution.
Persecution, yes. Your Honours, could we come back to that? It strikes me we're going to go beyond, regrettably, the second break, in any event, with the matters, and we would welcome the chance to discuss it over the break, and then come back and give Your Honour an answer. Your Honours, can we deal with it in this way? As Your Honours know, two matters arose during the course of our submissions day before yesterday. The first in relation, as I've just mentioned, Mr. Olmsted's reference to, as it were, the dual chains of command, which we would wish to address you on now, and which has been raised again by Mr. Karadžić and the defence team for Župljanin, and then Mr. Hannes on this question of the Stanišić interview. However, I don't know, did Your Honours rule on whether Mr. Župljanin could have a final word?
I'm sorry, I neglected to when I indicated that we were alerted to the application would be made, I should have said that the Chamber would allow him to have a word, and that would be the last thing before we formally close.
I see.
And coming back to the discussions that we would have had earlier in the week about the time for any wrap-up legal arguments, I suppose, subject to being corrected, that Rule 86A, to which I alluded earlier, that what we are doing now is conflating the two things. So, in other words, any rebuttal rejoinder that we would now hear would embrace those issues which to which counsel on both sides would have alluded earlier in the week.
Your Honours, I was about to say that. We do not seek to deal in a rebuttal with any of the factual matters, those that have come up, and those that we object to, we've raised effectively during the course of argument. We simply seek to deal with the matters of law. So if Your Honours are content, then if Mr. Olmsted can deal with the issue of the dual chains of command, as it were, and then Mr. Hannes can deal with the interview, and then I just have a few small points that arise from the final briefs.
Thank you, Your Honors. Firstly, yesterday, Mr. Zečević quoted my response to Judge Hall's question to suggest that the prosecution had changed its position with regard to resubordination, that we were now taking the position that resubordination applied whenever the police were participating in combat operations on the front lines. That is not the position of the prosecution. It has never been the position of the prosecution. We have continuously maintained throughout the trial that resubordination could only occur when the police were engaged in combat operation along the front lines. However, not all instances in which the police did engage in combat operations along the front lines were instances where they were resubordinated to the Army. Rather, resubordination rarely occurred during the indictment period, and it did not occur in relation to any of the crimes charged in the indictment. And I just point out that the CSB Banja Luka's year-end report, P624, makes the distinction between police participation in combat independently and police participation in combat as a resubordinated unit to the Army. So just to make that clear. And we refer the trial chamber to paragraphs 871 to 880 of our final brief, where we make clear our position and evidence on this issue. The legal submission I was making on behalf of the prosecution Wednesday was that even if the chamber were to find that with regard to a crime charged in the indictment, a particular police unit was resubordinated to the military, that does not mean, as a matter of law, that the accused were no longer the superiors of that police unit for purposes of command responsibility under Article 7.3 of the Tribunal statute. Rather, under command responsibility, a perpetrator can have more than one superior who has effective control over that perpetrator, and each of those superiors can be held criminally liable for that perpetrator's crimes. There are essentially what I would break down into two categories of tribunal cases that support this legal argument. First, there are a number of cases against military accused, which establish that perpetrators can have more than one superior, both within the same military chain of command, as well as in multiple chains of command. And I refer to the trial chamber, in this case, to Struger trial judgment, paragraph 365, the Naletilich trial judgment, paragraph 69, and the Blaškić trial judgment at paragraph 303. Second, there is a line of cases against civilian accused, which establish that, that perpetrators can have more than one superior within separate chains of command of different organs. In particular, the perpetrators can have a civilian superior as well as an army superior. And I refer you to the Alexovsky trial judgment, paragraph 106, the Colonel Yelets trial judgment, paragraphs 93 to 107, as well as the Popovich trial judgment, the paragraphs I provided on Wednesday. Let's take the Alexovsky case. The accused in that case was the civilian warden of a prison in Lashva Valley. As a defense, he argued that the guards at the prison who committed the war crimes at issue were members of the military police, and therefore he had no superior responsibility over them. The guards had their own military chain of command that was responsible for their actions. The trial chamber disagreed, finding at paragraph 106 the issue whether the guards came concurrently under another authority, such as the military police commander, in no way detracts from the fact that the accused was their superior within the confines of the Kaonik prison. Now, the prosecution submits that an analogy can be drawn between that case and what occurred at Manjača camp in 1992. Even if the trial chamber were to accept the defense argument that the police officers from Sanski Most and Kluč, who were sent to Manjača by CSB Banja Luka to assist with guarding that facility, were resubordinated on each occasion, each shift that they went to that facility, it does not automatically follow that their only superior was Colonel Popovich, the camp commander. While at the camp, the colonel undoubtedly gave the police officers who were performing guard duties orders and instructions. However, the police superiors also maintained effective control over these police guards, determining which police officers to send to Manjača and for how long. And as the prosecution submits, they exercise ultimate disciplinary and criminal jurisdiction over these police officers. Now, in the Popovich case, the accused Borovchanin was the Ars MUP deputy commander of a joint MUP force that included several police companies that participated with the VRS in operations in Srebrenica in July 1995. As a defense, he argued that one of the police companies, the Jaharina recruits, was under the command of the VRS Bratunac Brigade security organ while committing crimes in Podachari on the 12th and 13th of July. The trial chamber in that case found that even though the Jaharina recruits were resubordinated to the army, Borovchanin maintained effective control over these police officers. In making this finding, the trial chamber relied on part Article 14 of the 1994 RS Law on the implementation of the law on internal affairs during an imminent threat of war or state of war. That is L317 in our case. And that law states, Article 14, police units shall be under the direct command of a commander who is a member of the Ministry of Interior. During the time they are resubordinated to the Army of Republika Srpska, they shall retain their organization and may not be split up or separated. The trial chamber then found, as Ms. Butler pointed out, that this law established a unity of command principle of MOOP forces resubordinated to the VRS. And that's at paragraph 1567. The prosecution submits that this 1994 law, which I just quoted, is nearly identical to Stanisić's 15 May 1992 order establishing the police war units, which required that if those units were subordinated, and they weren't always subordinated, but if they were, the ministry units shall be under the direct command of certain ministry officials. Just cite that's 1D46. Now, as Ms. Butler attempted to do, of course, if you look at these cases that I've just mentioned, you will find factual distinctions. That's inevitable. This case that we have before us is unique in that we are charging high-level police officials for the conduct for perpetrators at quite a low level. But what we do submit is that this jurisprudence establishes the general legal principles that Your Honor should use as a guide when you're addressing these, to a certain degree, novel legal issues with regard to resubordination. And we submit that the underlying point of this jurisprudence is that the concepts of resubordination or unity of command are not decisive of the accused's command responsibility. What is decisive is whether the accused could exercise effective control over their subordinates. This is a question of fact, and as the prosecution has explained throughout its final brief and in its closing arguments, this has been established by the evidence.
Before you hear from Mr. Hannes, do you want to hear from the other side on any of these matters?
I think it would be more efficient to hear all of the prosecution's submissions, and then we'd hear from the other side.
Thank you. Your Honors, good morning. I just want to talk briefly about the issues raised concerning comments about Mr. Stanisić's suspect interview with the OTP in 2007. This is not in the nature of a comment of the kind prohibited by the statute as held in Celebici. What this was about was what Mićo Stanišić said and what he left unsaid during his 2007 suspect interview. And you'll recall that was an interview that was done with his counsel present. You can read in the interview that he was advised of all his rights and reminded of those rights each and every day of the interview. He freely waived those rights and agreed that his statement could be used at trial. He answered some questions, but he didn't answer all questions. He said there were some matters he didn't want to talk about. Mr. Zečević has tried to claim that since we, the prosecution, put the interview into evidence via a bar table motion, that means we vouch for the truth of its contents. That's not exactly correct, Your Honor. We don't. And I dare say we never said that. You can see in our bar table motion, 2nd December 2010, his interview was 65 ter number 2827.01 through 2827.14. It's listed in Annex A to the motion, which is at, I think it's the registry's page number D is in David, 10335. And the column in the table that is entitled Relevance to Case Issues, we said that his interview was, quote, the interview conducted under caution with the accused, Mićo Stanišić, provides evidence of his position on many issues of relevance to this trial. That's all it said. Had we, and frankly, Your Honor, had we believed that everything he said in his interview was true, we would have been ethically bound to dismiss the indictment because he claimed he was innocent. This is being offered to prove many other matters. And also the issue about whether we decided to tender it into evidence, you should be aware that there's ICTY jurisprudence in a case whose name I will butcher. It's Ndayabaye, N-D-A-Y-A-M-B-A-J-E, et al. My apologies for my pronunciation. It's ICTR 98-42-T, the 15th of May, 2006, appears to hold that if the prosecution does not tender such a statement, in its case, it may be precluded from using the contents or the substance of such a statement in the defense case. And in the event that the accused did not testify in a situation like that, the prosecution wouldn't be able to use it at all. Now, by not objecting to the use of his statement at trial, Mićo Stanišić put his credibility at issue. And it's not unfair or inappropriate for you to consider what he said and what he left unsaid or refused to say at the time of that interview when you decide what weight to give his interview, in whole or regarding specific parts of that interview. I would just indicate I come from a jurisdiction where the general rule is that hearsay is not admissible, as opposed to here, hearsay is generally admissible. In the system in the U.S., an out-of-court statement of a witness is hearsay and generally not admissible. But there's an exception for admissions by a party opponent in a civil case or a criminal case. They are defined as being not hearsay. And the theory is that if a party admits something that's contrary to his interest, his pecuniary interest or his penal interest, it's more reliable than self-serving statements. We believe that in this situation, it's entirely appropriate for you to consider claims made by Mićo Stanišić in his interview, which neither panned out in determining what weight to give his words. Contrary to what Mr. Zečević has tried to assert, that is, that everything he said in 2007 was true and turned out to match precisely the evidence presented at trial, that's simply not so. We gave you one example earlier in closing. His claim that between April and September 92, before the autonomous regions were banned in September, he said no CSB or SJB chief ever cited or relied on one of his or his assistant minister's orders. That's absolutely not true. We showed you 3 specific examples, and there are many more. Finally, he didn't have to speak at all. He had an absolute right not to speak to the prosecution. But when he voluntarily and knowingly waived that right and proceeded to selectively answer some questions but not others, he cannot preclude the prosecution from arguing or you judges from considering that selectivity in 2007 in deciding what weight to give that total evidence. That's our submission. Thank you for hearing me.
Čujete mi sada proba?
Judge Half's question.
All rise, full away.
Sad, zašto nije moglo?
Čekaj, ja sad.